Good evening, Imelda. Good evening, Amanda. Thank you so much for joining. So we'll be starting shortly. I would like to try to get a few people on call so that we would commence immediately. Can we all hear me? Can we hear me? Can we hear me? Can we confirm that we can hear me? Good evening. Good evening. Can anyone hear me? Okay. Okay. Thank you, Amanda. All right. So good evening, everyone. Thank you so much for joining in. Welcome to the JIIPCC Mentorship and Internship Program. We are currently in week 3 of our mentorship program, and it has been an interesting journey so far. We have started from week 1. We started in week 1 with introduction uh, into alternative dispute resolution, and then we moved on to in week 2 to discuss about mediation and career opportunities in mediation. And in week 3, we'll be discussing arbitration and career opportunities in arbitration. My name is Dennis Williams. I'll be your moderator for this session. So we'll be starting shortly, even though I expect that we should be more than this on the call. Thank you so much, Ms. Omotayo, for joining us. We are happy to have you in class. You're welcome. We'll be starting the session as soon as we can. All right. So not to waste any time, since we've already started and we have one mentor already in call, we'll be doing well to introduce the mentors that we expect in today's class, and we'll be reading their profile as is our custom. Today, I will not be reading everything on the profile of our mentors, seeing that they're a bit lengthy. Um, Seeing that is a bit lengthy, and would want to just get straight into the business of the day. So our first mentor for today, our very consistent mentor, that's in the person of Mr. Nyacham Nanwang, who happens to be the executive director of the Settlements House ADR Training Institute. Nacham Nawan is a lawyer and the principal partner of the law firm N. Nacham and Co., a law firm based in Kaduna, Nigeria. He's a certified teacher, trainer, and facilitator. He is a faculty member and the executive director of the Settlement House ADR Training Institute, SHATI, an institute for training, certification, and practice of alternative dispute resolution. He is also a member as well as faculty member of the Nigerian Institute of Chartered Arbitrators, a model arbitration certification institute in Nigeria. He is a certified dispute resolution specialist, an international mediation campus trained mediator, an attorney mediator, a certified mediation advocate, an arbitrator, a certified negotiator, an ADR practitioner, a restorative justice practitioner, and a certified emotional intelligence specialist. He is a certified conflict manager, a certified ADR registrar slash secretary, a holder of Mediator Academy United Kingdom certificate in commercial mediation, accredited by the Institute of Chartered Arbitrators UK, a medical law enthusiast, an employment and labor law expert. Not to go further, I'm sure we are all familiar with Mr. Nyacham. We've had the opportunity to read his profile since week 1, right? So I'm sure Mr. Nyacham is no stranger to us. Our second mentor for today, who is already here with us on call, is Miss Blessing, Miss Omotayo Blessing Uwune. Yes, Ms. Omotayo Blessing is a highly experienced legal practitioner and mediator with over 15 years of expertise in soliciting, advocacy, corporate law, and property consultancy. A dedicated professional, she has built a distinguished career in legal research, drafting, and alternative dispute resolution. Omotayo obtained her LLB, that is her Bachelor's of Law, from the University of Jos in 2008, and was called to the Nigerian bar in 2009. She later earned an LLM from the same institution in 2018 and is currently pushing for her PhD in law. She began her legal career at the Court of Appeal JOS during her National Youth Service Corps um, NYC program, where she honed her skills in legal research and drafting. Over the years, she has worked with reputable law firms, including Solis Chamber and Leo M. Ibe and Co. before establishing herself as a private legal practitioner in 2021. Her passion for alternative dispute resolution led her to become a certified mediator with the Settlement House Area Training Institute, SHATI, with a strong commitment to justice and effective conflict resolution. Omotayo continues to provide top-notch legal service and mediation expertise. She's based in Jos, Plateau State, and she can be reached via email at babylawyer83@gmail.com. Thank you so much, Miss Omotayo, for joining us. We are happy to have you in class. Our last but not least of our mentors that we're expecting in today's session is Miss Pa Fry Awasum. Yes, Miss Pa Fry Awasum. Sorry, let me try to zoom in. Um, Miss Pa Fry Awasum, arbitration associates arbitration/ADR associates at Ames Capital, it's Ames Capital and Associates L Limited, Kigali, Rwanda. Awasum is an international arbitrator, mediator, and conflict resolver with over 10 years of experience, currently serving as branch manager of the Chartered Institute of Arbitrators, UK Rwanda branch. Perform her services with the highest standards of professional and ethical competency and integrity. Awasum has served as a tribunal secretary in multiple international arbitration proceedings, specializing in investment disputes, commercial transaction, supply agreements, mineral resources arbitration. She is currently undertaking her first appointment as an arbitrator. Awasum has 10 years experience as a policy expert, speaker and trainer at international and national conferences, summits, and workshops. She has 10 years of experience as operations/program and project manager, expert, best female human rights and democracy advocate in Cameroon, awarded by the Senate of Maryland in the United States of America. Awasum holds an MSc in Development Studies with specialties in Gender and Environmental Sustainability Policy, awarded by Kigali Independence University, an LLM in International Trade and Investment Law in Africa, awarded by the University of Disham, Cameroon, 2017, a bachelor's degree award by the University of Yaoundé, SOA in Cameroon, 2014. She holds so many other professional certifications and diplomas in her areas of expertise and practice. She is a member of the Chartered Institute of Arbitrators UK, member of African Arbitration Associates, East Africa Young AFAA representative, member Women in ADR Rwanda country representative, African Women in Arbitration, member African Young Arbitrators, Young ICCA and ICCYAA F member. She holds a diploma in legal research and development awarded by the Institute of Legal Practice and Development, Rwanda, in 2021. In addition, she holds a diploma in policy design and implementation and results-based monitoring and evaluation awarded by the Center of Development Policy, Rwanda, 2022. So Miss Mispa's profile is a bit lengthy and we may not be able to read all of it. Please kindly do well to follow us on LinkedIn. Our mentors profile are posted there. You can catch up with their professional history and experience so that you can familiarize yourself with our mentors. You can also make contact them and make significant or build significant networkings with them, right? And I'm sure they would try to help you in any way they can. So we've spent quite a long period, right, trying to introduce the session and all that. So we'll be getting straight into the business of today. So I want to kindly start just like we normally do. We would like to kindly start with the presentations from mentees. So I think we'll be having presentation from group 2 today, right? So please, I'll be sharing screen on behalf of group 2. I'll be sharing screen on behalf of group 2. So please, the group presenter, you can go ahead and start your presentation while I help you share your screen. Is the group presenter with us in class? Okay, do we have group 2's presenter with us in class? Please, we would like to commence as quick as possible. Okay, can we have somebody step in to make presentation on behalf of group 2 if the presenter is not able to start? Please, can we all hear me? Okay. Okay, so our presenter, are you ready? Okay, so that we do not waste any time trying to wait for presentations to start, what we will do is we will since we have Miss Omotayo in class with us already, we are yet to have two of our mentors joining yet. What we'll be doing is that we'll be taking a quick introduction into the session from Miss Omotayo. Like I said, our topic for today is mediation and career opportunities. Sorry, did I say mediation? Arbitration and career opportunities in arbitration. So, Miss Omotayo, please, we'd like for you to just quickly, let's say in the next 20 minutes, while we try to get our presentation ready, please can you just kindly help us to introduce the session and give us a breakdown into arbitration and the career opportunities into arbitration. You're welcome, ma'am.
Thank you very much, sir, and thank you all. So, when we talk about arbitration, we need to first of all know that there's slight difference. There's slight difference between arbitration and mediation. Like we all know, in mediation, there is actually mediation is party driven. So everything all about the parties, as we've said earlier, and as we all know. But the mediator does not descend into the arena, so to say. We're not supposed to, we don't decide for them, we only facilitate the communication so that we can help them to reach agreement or to solve their dispute, to resolve their dispute. So we cannot say a mediator is a judge. No, a mediator is not a judge. Now coming to arbitration generally, we can say the arbitrator is like a judge, because even after hearing the parties, an arbitrator has the right to actually reach a conclusion, so to say, to solve to provide solution to the problems or to the dispute. So that's just the tiny line between mediation and arbitration. So the arbitrator can actually suggest, or can even, in fact, not even suggest, decide that, okay, from what both parties, I've heard both parties, and this is now the decision that we are reaching from what we have actually heard from both parties. But we all know that that is not allowed under mediation. If not, if it happened that way under mediation, it can actually be challenged even in court. Now, talking about the career opportunity we have, in fact, I stand to even say that arbitration works more, especially in the commercial world, because most times it's difficult to say, oh, parties should like shift ground. You see that if you want to use mediation strictly in commercial dispute, then it might actually be endless. So when arbitration actually works better, because a decision has to be made, has to be reached, and then that decision will actually be binding, as we all know, because it can be entered in court as judgment and it can be enforced. So many career opportunities under arbitration. There are many, like even as I mentioned last week, that we like the multi-door courthouses that is usually attached to each high court, at least in Nigeria. Is not only mediation that is practiced there, we also have arbitration. So that means if you are a mediator and also maybe like an arbitrator, is a plus. So it's easier to even apply as a neutral there, and then it's easier to get than say, oh, it is only mediation that one is specialized in. Apart from that, there are also many ministries that also practice arbitration, because you know that everybody is now realizing that going through the rigors of litigation does not worth it when we can do it outside the courtrooms, reach the same conclusion, and also go to court and enter it as judgment. But some people might be feeling, no, maybe if I want to practice ADR or arbitration, I might not be paid. That is not true. It's just like maybe, let me say, maybe like two parties now approach you as an arbitrator. Now say, oh, we have this dispute. And this dispute that we are having, these are the facts of the case, and you look at it as a professional that, okay, this can actually be handled. Then as an ADR practitioner, you can say, okay, I'm going to do this for you. And this is, and this is how much I'm going to charge you. So by the time the person compares what you're charging him to what is going to cost him if he goes through litigation, and also the time, the energy that will also be wasted. So, but you are ready to offer this, you are ready to do this within a shorter period of time. So many people are actually keen into it. Now, apart from being a private practitioner, I think there was a time I was opportune to attend a professional, like a seminar, but I always take advantage of attending seminars because it builds you up. It's actually for surveyors. So, and then I also deal on property, that's property law. I specialize on it. So I decided to register for it and I attended. And I was so impressed and pleased when the Commissioner of Lands, that's in Plateau State here, now said, even in Ministry of Lands, because they have so many cases, so that even in that ministry, that they have introduced ADR. Even though they are not professional, but just like he just felt that these are some of these disputes can actually be resolved. I said, oh, wow, I didn't know. I was only thinking it's only the high court, maybe the multi-door courthouse. So after the seminar, I approached him. I said, I'm also an ADR practitioner and I'm a lawyer. I was surprised. He said, so what are you doing there? I said, I use every opportunity to upbuild myself, to upgrade myself, because I also deal on property. So since they're talking about property, I decided to register. I said, oh, that's good. So I said, but I'm interested in this your ADR. So in your ministry, you mean that just as the commissioner, you decided to also start ADR? He said, yes. See, and then they have been giving, they have been getting results, and then decongesting the court, because as you all know, you know that land matters form most of the cases that we have in court. That's if one is a lawyer. Even if you're not a lawyer, you know, everywhere you go to is always about land matters. But then he said, with this, they have been decongesting the court. I said, okay, I'm interested. He said, oh, really? I said, yes, that I'm even a professional ADR practitioner. So he said, okay, no problem. He gave me his number and said, whenever they want to have opportunity, that they want to have a session, that is going to invite me. So you can see that it's like a way of penetrating into that ministry now. So from that time onward, whenever they have a session, he's going to invite me and say, okay, that I should observe. And even though they are not even professionals, and then I'm also now there to, I'm learning, because I'm also learning from that angle, because even though they are not professionals, but at least they are doing it their own way. And then me too, I can also bring professionality into it. So is it possible as maybe like as an arbitrator or ADR a practitioner, for us to also look into these ministries? You know, I mentioned the other time that if one wants to go far in whatever one is doing, and then maybe even this ADR practice, you don't put money first. But with time, when you penetrate, the money will come. You see that even people that are even coming, like parties. Like the other day that I went, somebody said, okay, you're a lawyer. I say, yes, I'm a lawyer and I'm also an ADR practitioner. I said, okay, that's good. My contact is already there. I'm already penetrating there. So if there is an opportunity now, they will actually invite me. But when we say, no, it has to be money and things like that, then we might not go far. But I said, we can look into these ministries. So the ministries around you, can you just go? Do you people have any, maybe like ADR session? Or is, you know, you don't have to take everything to court. We can help you to settle. And then when we settle, it will still have the same, effect, because this settlement, terms of settlement, can actually be taken to court and then be entered as judgment, and it's actually going to be binding. So the sky, in fact, is not just a limit, it's like the beginning in ADR practice and even in arbitration. So we can just be looking inwards. Even when you, maybe if you're a lawyer, even if you go to court, and then, or maybe your clients approach you, we don't have to push for litigation. It's better for us to propagate for this, because it saves a lot of time and it gives you that fulfillment, that joy, that you are actually helping to preserve relationship instead of going into litigation proper. So I will encourage us that it is actually a call for us to try to, in our own ways, so that we can study the law. Let's study the law that is actually regulating arbitration as well as mediation, which is the armor That's the Arbitration and Mediation Act of 2023. So we want to know what it's all about so that we can actually practice as professionals, and it's actually paying off. And we are just starting, we should just continue to learn, to pay the price. We will also join the league that will actually get benefits from this mediation. So I welcome you all once again. I'm sure the other mentors too, I don't know if they have come, but I'm sure that they will have more things to say. So thank you so much for the opportunity. Thank you.
All right, thank you so much, Ms. Omotayo, for that wonderful introduction from you. So yes, we will now be going back to our presenters, right? Our presenter rather. So please, if you can, please go ahead and start. Group one presenter, please go ahead and start with your presentation.
Okay. Good evening, everyone. Am I audible enough?
Yes, good evening. We can hear you.
Thank you. Okay. My name is Amanda. I'm a member of the Group 1 for this mentorship program. For my group, we were given the topic career opportunities in arbitration, as you can see on the screen being displayed. Okay, and we subdivided this topic into 10 sections, as seen on the screen. So I would like to start with the introduction. So to my understanding, arbitration involves a neutral third party who is known also as an arbitrator or an arbitral tribunal, who has the dispute and renders a decision, which is known as an award. Okay. Arbitration in Nigeria is presently governed by the Arbitration and Mediation Act of 2023, like the mentor previously mentioned. Arbitration most times, as you can see from the slide, is mistaken for mediation, but there's a slight difference in the fact that a mediator is more of a judge. Sorry, an arbitrator is more of a judge than a mediator. A mediator wants to lean to both parties rather than an arbitrator. An arbitrator is just there to judge and give his final verdict, which is known as an award, which I mentioned earlier. I would like to dive into the arbitration rules. As you can see on the screen, we have a few. I'll start with mediation and conciliation. Okay. So mediation and conciliation involves a neutral third party who settles a dispute. Though the decision of the mediator is not binding, and the conciliation service usually attracts a process through strenuous, rigorous, formal, and time-consuming. Like I mentioned earlier, the mediator is more of a neutral party who is trying to bring about a settlement. But in an arbitration, the final decision, which is known as an award, is legally binding in Nigeria and can be equally enforced in a court of law if it gets to that extent though. Also, under arbitration rules, we have policy making and advisory rules. I will liken this to the fact that the arbitrator is experienced and he understands the arbitration laws and the practices and how to implement them during the process. So that gives him the opportunity to make better policies and advice also. Next, we have academic and research. Professional arbitrations also has it to be taught after all, that an arbitrator can have a career in teaching, research, or academia, focusing on arbitration and alternative dispute resolution as a course of study. A mediator on his own can be any type of person, can be a lawyer, can be an engineer, can come from any walk of life, nevertheless. But when they find themselves in this role, they have to dive into more of research to be able to advance themselves and do better in whatever session they have before them. I would like to go back and talk about diplomacy arbitration. This deals on the international arbitration. This cuts beyond Nigeria and the Nigerian law, which deals on Arbitration and Mediation Act 2023. Here, we're dealing with a wider scope of arbitration, which I would liken more to companies and institutions that have larger branches outside Nigeria and set arbitration and mediation as a means to reconcile themselves. This also gives arbitrators the opportunity to work extrajudicially and across international borders, as the case will be. I'll also like to dive into arbitration in specialized field. From our last session, we were given the opportunity to realize that arbitration cuts across various sections other than family disputes, company disputes, employment disputes. It can also have to do with technology, healthcare, cybersecurity, taxation, divorce, not necessarily divorce petitions per se, but family-related matters that go beyond that, as the case will be. That can also dive into arbitration. And lastly, I will speak on Arbitration Institute. An arbitral institute is a service provider that administers proceedings under its arbitral rules, and the institute of course employs professional arbitrators and offers a wide range of roles from case management to administrators. To the best of my knowledge, within Nigeria and outside, there are a lot of ADR institutions that train lawyers and also other personnel in different walks of life to become arbitrators, as the case will be. We have a handful. I can mention the Institute of Chartered Mediators and Conciliators. And also that one is sectioned to Nigeria. And international, I've come across Prime Dispute UK, which offers membership, associateship, and fellowship to different walks of life of lawyers within Nigeria, India, UK, US, as the case will be. I would like to dive into the other types of arbitration, which is in the next subsection. Like I explained earlier, arbitrators are usually used to resolve family, employment, online, sports, and company disputes, as the case will be. And as we can see from the types of arbitration, family arbitration is where the arbitrator is professionally trained to assist families through the process of divorce, inheritance, separation, especially as it pertains to children and finances. Like I mentioned earlier, the arbitration also leans towards family arbitration to settle certain processes that it's allowed to. And then we have employment arbitration, that's during workplace disputes. What will naturally not get to the National Industrial Court and can be handled within arbitration. The employer and his employees will rather lean towards that. We also have online arbitrations, where we have an e-arbitrator who arbitrates on disputes remotely using digital platforms such as Skype, Google Meet, and other relevant platforms, as the case will be. For that, I'll liken it more to probably a dispute on Twitter. And by the end of the day, they will have a chat room where someone will be appointed to arbitrate on two persons who had an online dispute, for which they can finally reach a decision to gain a award. And then we have sports arbitration. It deals on disputes within the sports environment, such as appeals against disciplinary sanctions, or players' eligibility. We see this every day where in the sporting environment, I'll say, they set up tribunals. These tribunals help to settle matters in closed room before it advances to courts, as something that can easily be resolved between both parties and an arbitrator, as the case will be. I'll now move on to specific arbitration rules on the next slide. Here we deal on the parties to alternative disputes leaning towards arbitration. There we have the arbitrator. He is the professional who is specialized in arbitration. He has an automatic career perspective as an arbitrator. And in most situations, you have to be certified to be able to, find yourself in this role. We also have the mediator, who will also play a part to facilitate negotiation between the disputed parties to reach a settlement. It's quite similar to arbitration. However, it's not as rigorous or formal as arbitration would be. I would like to say that arbitration most times usually leans towards litigation to an extent, but there's this difference that singles it out from litigation, which we now bring in a litigation lawyer. He specializes in arbitration by representing the client in court proceedings relating to arbitration. The litigation lawyer stands in, most likely has a witness to guide, or rather has a guidance to guide his clients, because the clients are the ones that will most likely present their matter to the arbitrator for him to make a decision and give an award by the end of the day. And lastly, we have the arbitration consultant. This is an expert that gives solid advice on arbitration procedures and strategies to employ or to put in place for an arbitral case. The arbitrator, yes, is a professional in his own case, but he will also need a consultant who will be able to advise him or work hand in hand with him or her to be able to finalize and make better whatever disputes they have before them. We'll move on to the next section on the slide, which is arbitrability of disputes. Okay. Under this, it says that arbitrability, is the concept of determining whether a dispute is arbitrable. That is, if it can be submitted for arbitral settlement. Like I mentioned at the beginning of the session, not every matter can appear in a court during an ADR session, as the case will be. So they will have to differentiate on whatever dispute comes before them, if it is something that can be handled via arbitration or it will be moved to litigation, as the case will be. Arbitrability matters revolve around two main concepts, which is subjective, also known as arbitrability rationale person, and objective arbitrability. Okay. Subjective arbitrability refers to where the parties involved have the capacity to arbitrate. That is, the parties may be precluded from submitting their disputes to arbitration as a result of their legal status. In this case, like I mentioned, whatever the disputes will be, you realize that the legal status of the disputes leans more to litigation than arbitration. It's not something that an arbitrator can make a decision and give an award over, and they will have to stand by it. No, it's something that has to go through litigation rather. And then we have objective arbitrability. It assesses whether the subject matter of the dispute is suitable for arbitration. Here, governing rules may demand some matters to be submitted to traditional courts only. Well, to the best of my understanding, I will say this leans more towards community disputes or family disputes, things that can be resolved within close range of family and community setting, as the case will be. We'll move to the next slide. Am I audible enough? Okay, it's moving. Okay, under the next slide, I'll be talking about settlement of disputes within international range. Okay. International conventions for the settlement of investment disputes mostly point out that arbitrability is governed by laws which are applicable to the arbitrator or the arbitration clause. In Nigeria, the principal governing rule is the Arbitration and Mediation Act 2023. However, there are other statutory enactments and case laws that govern arbitration. Under Section 1, Sub 5 of the Arbitration and Mediation Act, it provides that arbitration provisions apply only to disputes that are commercial in nature. Commercial in nature will lean more rather to company, employment, family, and community disputes. A criminal matter cannot find itself in an arbitration. No, this deals more on life, and arbitration hasn't gotten the authority to rule on criminal matters within the Nigerian laws, as the case would be. And then we have under Section 91 of the Arbitration and Mediation Act, it defines commercial to include matters that arise from all relationships of a commercial nature, whether commercial or not, such as trade transactions for the supply of an exchange of goods or services, commercial representation or agency, financing, banking, insurance. The list is long, but in essence, what I'm trying to explain is arbitration. Yes, arbitration leans more to commercial disputes than any other form of dispute in Nigeria. Okay. Okay, if I may, I would like to jump to the next subtopic, which talks about arbitration clauses and its significance. Okay, arbitration clause is a clause in a contract or an agreement that requires the parties to settle their disputes through arbitration. It's an agreement to submit present and future disputes to arbitration. Like I explained at the beginning of the session, most agreements between companies and persons usually indicate that we will go through the means of alternative dispute resolution before we find ourselves in court. This saves cost, time, and also breeding a bad relationship by the end of the day between the parties. On the next slide, we have the content of an arbitration clause. I'll list that one out. One, we have the nature of the contract, what the parties intend to achieve with the clause, what dispute will be resolved through arbitration, if there are other alternative dispute methods that can be explored first, the number of arbitrators that will be appointed and by whom, the venue that will be used for this arbitration session, what language, and what rules will govern the award of the cost. So if arbitration is going to be handled within Nigeria, has mentioned in the arbitration clause of whatever agreement is being signed by both parties, the Arbitration and Mediators Act 2023 is what they are going to rely with. Next, we have significance of an arbitration clause. The arbitration clause ensures that arbitration is fully explored before resource to litigation or any other way of resolving disputes, where the both parties are legally bound. Also, we have to note that having the clause in the agreement does not out the jurisdiction of the court. Where a party goes to court before resorting to arbitration, the other party is to apply to the court for the proceedings to be suspended pending arbitration. If by the end of the day the award given is agreeable between both parties, they can settle for that. Otherwise, they will move back into litigation. Our next slide talks about the escape of arbitration clauses in Nigeria. Okay. So under the Nigerian lens, I would like to mention that one, the lack of mutual assent, which is meeting of minds. Within the agreement both parties might have, they might either indicate or decide to remove the arbitration clause and settle rather for litigation. And where there is a meeting of minds and both parties do not agree to this, it brings about the lack of mutual agreement. Next, we have fraud, duress, or misrepresentation. Okay, most times parties who do not go through any agreement given to them, they are most times tricked or forced into signing such contracts, including the arbitration clause, where they will rather lean towards settling whatever dispute arises from the agreement rather within the courtroom. Next, we have unconscionability. It says that, it explains rather that within Nigeria, the court can refuse to enforce an arbitration clause if it is deemed unconscionability, meaning it is grossly unfair or one-sided. The end result of arbitration should rather be win-win, not a win-lose. It should never be one-sided. Even if one party or both parties do not get 100% of what they want by the end of the day, at least it should be 50-50. And the court will also be conscious of that by the time they want to enforce this award, which has been given through arbitration. And then we have illegality. It says that if the arbitration clause violates Nigerian laws, it becomes unenforceable. Certain types of disputes may be excluded from arbitration by status. Certain criminal matters, for instance, cannot be submitted to arbitration. Next, we have waiver. Here, a party can waive their right to arbitration through their conduct if they initiate a court proceeding instead of invoking the arbitration clause. They may be deemed to have waived their rights, and the Nigerian courts will also recognize this concept of waive. And I'll mention last, public policy. The Nigerian courts will not enforce arbitration agreements that violate public policies. And we'll move to the next slide. Okay. It says arbitral awards are the conclusive decisions which is rendered by arbitral tribunals involved in disputes. And these awards hold significant legal weight and serve as a binding resolution for the parties. It is defined as a final decision made by the arbitration panel or tribunal after considering the evidence and arguments presented by both parties. Unlike the court's judgment, An arbitral award is typically less formal and can be tailored to specific needs of the disputing parties. The binding nature of this award means that parties are legally obligated to comply with their terms and ensure that the resolution is honored. And if parties do not agree to this award, which is given by the end of the arbitration session, it can be legally enforced by the court. I'd like to move to the importance of arbitral awards. The components of arbitral awards are not merely prejudicial, they carry substantial importance in ensuring that arbitration serves as an important alternative to litigation. This reliability is particularly crucial in international commerce, where parties from different jurisdictions must have confidence that their disputes can be resolved fairly and effectively. Moreover, the ability to tailor the arbitration process includes the selection of arbitrators and the formulation of the awards, which allow the parties to address their specific needs and concerns. This flexibility is a significant advantage of arbitration over traditional litigation, which often adheres to rigorous prejudicial rules. Okay, the last slide, which is our conclusion. In conclusion, arbitral awards are a vital component of the arbitration process. It embodies the tribunal's final decision and it provides a binding resolution to disputes. The important components of arbitral awards include the introduction, statement of facts, issues presented, legal reasons, decisions, and the allocation of costs, which is essential for ensuring clarity, enforceability, and fairness. And at the end of the day, in a global economy, the role of the arbitration or the arbitral award in facilitating the effective dispute resolution cannot be overstated. Okay, that will be all for Group 1. Thank you.
All right, thank you so much, Amanda, for that very detailed presentation. Well done to you and your team members for putting it together. We really, I think we were able to grasp everything you were able to say. Your network was really clear. Well done once again to you and to your team members. I think Amanda has done such a great job in her presentation. So what we'll be doing right about now is we'll be handing over to our other two mentors who joined us while Ms. Omotayo was speaking. So we'll be firstly handing over to Mr. Nyacham. Mr. Nyacham, if you're with us, you're welcome, sir. Thank you so much for joining in. We have already started our discussion. Ms. Omotayo.
Hello, Amin. Hi,
Hello.
please give me. I've indicated to contribute so that I can step out. I'm actually taking a flight, so I can contribute so that I can drop out of the meeting. And then if my colleague, Mr. Anyachan, will permit and could take over after me, please.
All right, so that's fine.
If that's okay.
Yeah, so it's only one group that is presenting, right?
Yes, sir.
Okay. All right, now, Mitma, you can go ahead. Thank you for joining.
You're welcome, Nacho. Good evening to all the participants. Sorry, I'm joining you on this today's session from the airport because I'm catching a flight. Is it Blessing? Amanda, I listened to your presentation from the beginning to the end, and we did well, but something, especially when you are doing mentorship programs, you should be able to make reference. Because when you are a mentee on a program, you should be able to make reference to materials or to some cases to justify your points. You know, with technology today, we can actually get sources from anywhere with the AI and so on and so forth. But it's good as a young practitioner, when you get some of those terminologies or the technicalities you are presenting in arbitration, you try to refer some cases, even when you are making mention to the practice in Nigeria, but you didn't even refer even to one case or one situation to juxtapose or buttress your point. So that's the first remark I'd like to make. And then the second remark I want to make is about the difference between family arbitration and mediation. And this terminology of family arbitration is something that is seldomly used. In Africa, in my practice, I've never even seen any case of family arbitration. Sometimes there are theories that exist, but you cannot really lay your hands on any case so far that has been heard in that capacity of a family arbitration, because mediation is more suitable. And when you're talking about arbitrability, you're looking in the normal concept and theory of arbitration, we'll say divorce cases or family cases that especially touch issues of relations are not arbitrable. And then some matters in other countries, especially in the Muslim countries, so say South Korea, there are some matters that are considered matters of public policy or subjects of public policy. So the subject of public policy is a very bourgeois and contagious one. And also it is a principle of international public law. So sometimes what might be considered not arbitrable or a public policy matter in Nigeria might not be the same in Cameroon or in Dubai or in Europe or in the Americas. So the intentionality about public policy is to see that what the national law prescribes about public policy, that matter should be dealt with by the arbitrator, especially when their tribunal has been appointed and fully constituted. And now, but when it comes to international public law, public policy now, there are a lot of contradictions and different trends and narratives around public policy at the level of international law. Because if people keep insisting on public policy, it would definitely diminish the value or the integrity of arbitral awards. Because maybe a tribunal has sat on an arbitration, they have passed the award, and that award goes to a local country, or say the country of enforcement or the country of the seat, where they want to enforce that award. And then they said the matter was not arbitrable. The judge or the local court raises the subject of arbitrability. But no, with the international public law today and the New York Convention, you can go and enforce that award in another country that is a signatory to the New York Convention. So it is a very contagious subject, and academics are still working on it. I remember the last time I attended ICC training in Paris, this subject of international public policy on the arbitrability of some cases came, and we're still discussing. Several points came up, and then the IBA, the team that came from the IBA International Bar Association, they now took down some points to draft the guidelines in those domains and some other topics that were discussed. Please, I'm really sorry with the echo that is echoing behind me. I will just try as fast as possible to present. So you spoke about career opportunities. Amanda and other participants, I tell you, there are a lot of career opportunities in arbitration. As you keep practicing daily, you see there are different roles. And now it is for the young arbitrators to grab some of these new opportunities that are coming up. You know, there is a difference between a tribunal secretary and a registrar. And recently I joined the TSN, that is the Tribunal Secretary Network, where they are only a network of tribunals, of arbitral secretaries, where an arbitrator, mostly for ad hoc arbitration. An arbitrator might have an ad hoc arbitration and then go to the platform of TSN to seek the service of tribunal secretary to to be the secretary of that arbitration. So another role that you were trying to talk about was about advocacy. People that's another domain where either in the level of academic or general practice, I encourage young people to invest in, because as you are still starting your career, arbitration, it's a complex and delicate practice. That's the truth about it, because some of the claims, the amounts in the claims are so bogus. And it is not easy unless you have maybe a firm where you've been attached to, that you can be chanced to have openings to some of those cases and witness the proceedings. But if you dare get one, then it's a breakthrough for you. But why then? I encourage a lot of you to do arbitration advocacy by writing papers, taking opportunities to speak in different conferences, different trainings, different webinars, and even on the media, your LinkedIn, your Twitter handles, your YouTube. Create a YouTube channel and start advocating about arbitration, okay? Before you know it, you are gone. And then, Amanda, you said something of a litigation arbitrator. That a litigation arbitrator is like a weakness to the party. No, that's totally different. A lawyer doesn't come as a weakness to the client. A lawyer comes in the full capacity of the counsel, the legal representative of that party. And where they have weaknesses, they can call their witnesses. Or where the tribunal needs witnesses or expert witness, then they can ask with the consent of the parties, and then the tribunal can appoint the expert witness. And the IBA guidelines provide to us on how the tribunal is going to follow the procedures to appoint those expert witnesses, okay? And then the most interesting one now is an arbitration clerk. An arbitration clerk, if you're opportune, if you brand yourself as an arbitration clerk and they know you as an arbitration clerk, you sit in many of those arbitration as an assistant. You assist in case management, okay? You assist in case management, and then you maintain the communication between the parties and the tribunal, because in arbitration, once the arbitrators have been appointed, after the preliminary meeting, the arbitrators cease communication with the parties, okay, to maintain their neutrality, their independence, and the impartiality, okay? And now the arbitration clerk is the one who communicates between the tribunal and the parties. So sometimes, I know we young people, we look a lot about money. I advise every young person not to look so much about money. You can volunteer. Tell even an institution that you register yourself under their institution as a volunteer arbitration clerk. And I'm telling you, before you know it, you will blow, okay? But sometimes you must have, the minimum prerequisite or a legal background, okay? Or a legal experience, especially in administration, okay? To be able to be an arbitration clerk. And then under policy advisory roles, or be a policy advisor, like some of the things I'm building myself around as well, arbitration policy advisor. We actually specialize now at the level of advising governments, okay, or organizations or non-governmental organizations, so that they can also implement arbitration policies to ensure that they comply with international standards. Because, arbitration, mostly and much, they are domestic arbitration. Arbitration is mostly international. It's an international business, and every organization needs to see the government implementing this within their countries. Okay, and now also government agencies and non-governmental organizations, even think tank groups, think tank organizations, you go lobby such that they help in the implementation of arbitration in the countries or with the government. And then the last one I want to talk about arbitration career opportunities is a case manager. Okay, a case manager, in most arbitration institutions, you have case managers. Even in a law firm, they have case manager. That is arbitration case manager, different from litigation case managers. Okay, so you can apply. You can offer yourself to be an arbitration case manager. But remember, like I said, in the role of arbitration clerk, you should have that background of administration or some legal knowledge, being able to deal with disputes and make analysis, and then you submit to either the institution or your principal department in the law firm where they are in charge of alternative dispute resolution. So as a case manager, you actually work on the administrative aspect of the case, and then you also scheduling different types of scheduling, hearings, meetings. You coordinate with the parties as well, and then also prepare all the necessary documents. Okay, you can be a junior manager. There are different levels: junior manager, senior manager, assistant, academias, and lecturers, institutional arbitration staff, and so on and so forth. So arbitration is expanding, is growing, but now through advocacy and the sensitization that is played around institutions and governments, they are going to understand the practice and then create these opportunities in their institutions, the non-governmental organizations, and give jobs to the young practitioners who are joining the arbitration world. So those were the few remarks I wanted to make on the presentation. But if not, you guys are doing well. But like I said before, kindly, you are both welcome, Amanda. Kindly always, as a young person growing, kindly always make new friends to cases. There are a lot of free cases online. There are a lot of free cases on the ICSID website, the International Center for the Settlement of International Disputes. There are also cases on SIAB website free. There are also some cases on ICC website. So visit this website, get some of these cases, read them at your free time, okay? Even if you are taking materials from ChatGPT or from AI, but make sure you relate, contextualize it, personalize it, make it yours. And that's how you are going to blow in the career. I wish you all the best for this session and hope to catch up again in the next session. I say greetings to all the other mentors in the house and to Nancham. Thank you all very much.
Thank you so much, Ms. Mispa, for that wonderful feedback and insights from you. We really appreciate your presence here and everything that you do for us. You're very, 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 very much. We are very, 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 very much grateful. Thank you very much, Ma. So we'll be handing over back to Mr. Nacham. Mr. Nacham, if you're with us, thank you so much, sir, for joining.
All right, thank you very much. Let me start by appreciating all of you who are value your time for this mentorship meeting. That's very, very nice. I appreciate you. So without without waste of time, I want to commend the group that made presentation for your dedication, your meeting, creating time to put some things together, the purpose of this mentorship. You have done wonderfully well, and I must say that I appreciate what you have done. Now, the purpose of the mentorship, the goal is to create an platform for you to make contributions as questions. Please, can you confirm if
So your network is breaking. It's not steady. Hello, sir.
Hello, can you hear me now?
Yes, sir, it's loud and clear. With your video off, it's loud and clear.
All right. So I wish that some of us would use the opportunity to ask questions concerning some of the things that you need to carry. It's expected that you make some reads, make some research, so that the session is going to be an interactive for questions and then get clarifications where necessary. So I don't know whether any of you have any questions concerning what you have presented, what your colleagues have presented. Do you have any questions?
So your network is still breaking. I think it's your video that is affecting the audio, because when you turned your video off, the network was better.
Okay, so do we have questions?
Okay, from the side of our mentees, please, do we have any questions as it relates to arbitration and the career opportunities in arbitration? We'll be taking questions so that we can have an interactive session with our mentors. So please, if you have a question, you can either ask or drop your question in the chat box. Please, do we have any questions from the mentees? Please, if you have a question, kindly drop your question in the chat box or unmute yourself to ask.
Okay, so if they don't have questions, I will ask them questions.
Okay, there's a question on the chat box, sir. The question is from Amanda. Amanda is asking, what is the difference between the previous Arbitration and Conciliation Act of 1988 and the current Arbitration and Mediation Act of 2023 regarding the revoking of arbitration agreements? Hello, sir. Did you hear the question, sir?
The different well, the Arbitration and Conciliation Act is 2004, and revoking of arbitration agreement. Well, when it comes to can you actually revoke an arbitration agreement? Not really. In fact, it is irrevocable. Once you have an arbitration agreement, you have to conduct the arbitration. There is nothing like revocation. In fact, even if a party dies, that does not actually revoke the agreement. Amanda.
Okay, I'm here, sir. I can hear you.
Yes, I say even if a party dies, right, it does not revoke the arbitration agreement. When parties have agreed to do something, and they said they are going to resolve their dispute via arbitration. Even if you take other steps and you go to to court, for example, you are going to be referred back. All that is needed is you file you can file a notice of preliminary objection, and in respect to the matter that has been filed where there is an arbitration agreement, you are not going to file your statement of claim, your statement of defense to this. All that you need to do is to file a memorandum of appearance without any further particulars as to your defense, because it is expected that once you file that, the court should be able to refer the matter back to arbitration. So that's one important thing that we are supposed to know. So no revocation, assuming you gave it a condition that you needed an let's say an arbitrator who is like 25 years post-call and must have specialization in medical law. Those conditions, even if they are not met, that does not on its own revoke the arbitration agreement. It does not revoke the arbitration agreement. It does not. The highest, the best, what will happen is to get another arbitrator, agree to set another standard. So, but when it comes to revocation, unless if the arbitration, is maybe expressly illegal or against public policy, because that is what we call arbitrability. It's not every dispute that you can arbitrate on. Arbitration that has to do with criminal offenses, anything that has to do with maybe contrary to public policy, some of those things are exempted. They are not things that you can arbitrate. Illegal contracts, you have agreements that are entered into by underaged. So for those who are in the legal field, for example, the law of contract has gone a long way to set some of these standards and expectations for us. It makes things easier. It makes things easier for us, because the lawyers are now aware of the law of contract. You have void contracts, you have the conditions to be met for you to have a valid contract, among several other things. So that is what we need to take note of. I don't know if is it Amarachi? What's your name?
It's Amanda.
Amanda, yes. I don't know if I've attempted your question.
Yes, you have, sir. I would also like to ask lastly, what extent can the courts intervene to an arbitral award? That's the extent of court intervention to arbitral awards. How far can it go?
When you say
and what
intervene,
options do you have?
what aspect are you looking at?
Enforcing it.
When you say intervene,
The enforcement of an arbitral award.
The enforcement. Enforcement of arbitral awards. The court. Well, To what extent? You cannot enforce an arbitral award without using the machineries of the court. So, in as much as arbitration is a private way of resolving disputes, but you cannot do so without the court. So, when you resolve privately and every other conditions has been fulfilled, when every other condition is fulfilled, when you have fulfilled every other condition, you have a valid award. What you need to do is to file an application for enforcement, just an ex parte application to a court within the jurisdiction. And the court, according to the new law, refers to the High Court. So you go to the High Court and file an application. You are going to an motion ex parte, for example, and then you do your affidavit and state the fact that, okay, there is an arbitration that was conducted between so period of time. And after the conduct of the arbitration, you you got an award. An award was published in favor of in your favor. You exhibit the original copy of the award. If the award is published in other language other language aside from English, you have the certified true translation of that. You have a certified true copy of that. And then once that is done, what you need to do is you attach those things and file it before the High Court. When you file it before the High Court, your application will be heard. And then when everything is done, then the court will now give you the authority. Possibly what you are applying for is for the court to take jurisdiction over that said property and make it like the judgment of its court. So by the time the court adopts the award, it's going to give it the force of law, like the judgment of court. So that's the application. You are asking that you want to register, just like you register judgment if you want to enforce them in another jurisdiction. You are registering the arbitral award for the purpose of enforcement in that court. So they are going to, once the court grants it, is going to enroll the order, and then the court you will explore the court's machineries, the bailiffs and the police and all of those involved in the execution of judgment. You will invoke them, then go to execute the judgment, just like the judgment of the court. So every award that you do, the court is involved in its enforcement. That's why you have the seat of arbitration, you have the seat of arbitration, and then you have that's the governing law, the law that governs, and then you have the law that has the physical location where the arbitration is being conducted. So when you talk of the seat, you are looking at the law that is going to be applicable in case there is need for you to apply for an emergency arbitrator. You need to apply to court to appoint an arbitrator. You need to challenge, the appointment of arbitrator. You need to do one or two things that you need the court. If you need an injunction or you need to compel someone to come and testify or subpoena someone, all of those things, those are the seats of arbitration. That's the law that is going to be applicable. So you can be sitting in London, but the law, physical sitting in London, but the law that is applicable is Nigerian law. So those are that is what you should look at. I don't know, Amanda. Okay, yes. I hope you that is of some help. Is that okay?
That's okay by me. Thank you very much, sir.
Okay. All right. So
So please, do we still have more questions from the mentees? Do we still have questions that we'd like to ask?
okay, so if you don't have question, I didn't want to just be talking. I have a lot of things to talk. In fact, we will not get, I don't, the time will not even be sufficient. If you don't have question, I can just talk, do my, make my contributions. I feel that when you are asking question, it adds more value. You ask questions that are relevant and have value to you, that you appreciate, instead of just uh,
Sir, your network is breaking once again.
so my
Hello, sir.
yes. What I'll do is, let me see if I can switch to June.
Hmm. We can't really hear you anymore, sir. Sorry. Okay. Sorry once again. Mr. Nyasham is having a little issue with his network. I'm sure he'll be joining us shortly. Sorry, my video is not turned on. My background is very, very dark. I do not currently have power where I am at the moment. So sorry about that. So please, while we wait for Mr. Nyasham to join back in, I would like for us to, for those of us that may still have questions, that you can send in your questions. Right, we have one of our mentors, Miss Omotayo, still with us, if I'm not mistaken. Okay, she's no longer here. All right, but okay. All right, so thank you very much, Emelda, for your question. Once our mentor joins back in, he'll be responding to your question. Thank you. And also, I want to kindly say that the questions do not have to start and end in class here, right? We have Ms. Tanya Cham on our general group, so you can always send your questions to the group chat. If you have any questions like post or outside this session, you have or you come across or you encounter a question you would like to ask over the course of the program, you can always send your questions into the chat box. Thank you so much, Ms. Omotayo, for joining back in. So Ma, we have a question here. I don't know if you'll be able to answer it. I would be reading it out to you. so that, to get your feedback or response to the question. The question is, how do we enforce an international award in a country where the award that was made is against its public policy?
How do you enforce an award? Why will you enforce it? That's why in the first place you don't you cannot do an arbitration against something that is against maybe you have something that is against public policy. You are not supposed to do it at all, you know. So let's say for example somebody says you have an agreement that you are going to supply uh, confirm if you can hear me please.
Yes, sir, we can hear you, sir.
And let's say somebody's country, you have an agreement that you're going to supply, let's say, 50 prostitutes, to somebody, and the person agreed to pay you certain amount of money. And after paying the money, you fail to supply the number of prostitutes. And then you have an agreement with the person that in the event of any dispute between you, you are going to resolve it through arbitration. You go and then initiate an arbitration proceeding. A mediator is appointed. By the time he signs the agreement and sees it, right away, will either decline, say that this contract is not enforceable. This agreement between you is against public policy, so you cannot. So even if they go ahead and they have an award that is delivered, that award is still unenforceable because it's against public policy of that particular country. And some of these things are actually universal, so to say, like some of the laws that we have. Nobody says you should keep prostitution. I don't think is allowed, is permitted, and as something that is legal, so to say. So most of those things, dealing in arms, several other things like that, if you go and you are mining resources from another country, let's say all these precious resources from another country without any relevant license. If a dispute comes in, will you be able to go and do arbitration or do settlement? Because you don't have a basis. And every country has its own public policy. So you can't enforce an agreement that is against. In fact, you are talking of against a country. You are not talking, even if it is between individuals, it's not something you can enforce, so to say. Are we together?
Yes, sir, we are. Thank you so much, sir.
All right. Who asked that question?
The question was from Melda.
Okay. Amanda. Amanda, you are going to get an award.
No,
I think.
Emelda.
Yeah?
Emelda Iwi.
Okay.
Emelda Iwi. Yes, that was the person that asked the question.
Okay. All right. So now, having said so, let me just give us a general overview so that we have an understanding for the time that we have. Can we do that?
Yes, sir, we can do that, sir. Please go ahead, sir.
All right. Thank you. Now, before you can talk about arbitration, generally, we said it's an alternative way of resolving dispute. And an alternative in the sense that it's a private way. Now, when we say alternative, we don't mean that it's inferior. No, but it's another avenue of resolving dispute. And most so, it gives the parties opportunity to decide a lot of things for themselves. Our normal court system do not give us opportunity for parties to decide for themselves. A third party who is appointed by the state, whether they like it or not, whether he has the specialization or not, is appointed to adjudicate over your matter. And you cannot influence the person. Another person may have specialty, but you can't appoint the person. Another judge may have, but you may not be able to appoint the person. They just assign, the CJ assign the case. But in arbitration, you choose. You are going to choose the arbitrator. You are going to agree on the fee you are going to be paying. You are going to agree on the venue. You are going to agree on the law that is applicable. You are going to agree on the period of time you want the arbitration to be conducted in case it happens. You are going to set time. You said, okay, first we are going to try negotiation. If it fails within 30 days after, we are going to try mediation. If it fails within 20 days after, we are going to initiate arbitration. Parties are the ones who do all of those things. So by the time, before you can talk about arbitration, there must be an agreement, and that agreement is agreed by parties. This agreement mostly, it can be done at the point where the parties are about entering into the contract, such that it's going to be incorporated into the contract, or it can be done at the point where a dispute has arisen. We advise that if you have a dispute, always incorporate, if you have a contract on an agreement, incorporate means of dispute resolution. Dispute resolution mechanism should be part and parcel of your agreement, so that you avoid unnecessary litigation and all of those things. So if that is done, the Arbitration and Mediation Act 2023 clearly help us to understand that once there is an agreement, and that agreement is binding between the parties, and it is enforceable against the party to the exclusion of any other dispute resolution method. So if you say it's arbitration you are not using others. It is that one that you're going to do. There is nothing like saying, no, I'm not interested again. Once you enter that agreement and there is an arbitration clause, whether it is poorly drafted or is not properly drafted, you have to sort it out. Then you have to go for arbitration. Assuming somebody goes to file a case against, even when there is an arbitration clause, I've told you what to do. You file a notice of preliminary objection, but don't file a defense. File a memorandum of appearance. And the new law as it is now, says that once where there is a dispute that is time bound, and the moment the matter, there is a matter in court, and then there is an arbitration clause, time will not be running while the matter is still in court. And the court has been asked that, according to the law, that they should send the matter back for the parties to go and do the arbitration, after which they will come. But once they send you back, you are not going to come back to the court, because the arbitrator will decide the matter one way or the other, and that brings the dispute to an end. You don't appeal against an award. You can only apply on certain grounds to set it aside. And those grounds are very, very limited and restricted. Misconduct, which you have to prove, So that is that. So by the time parties inculcate those things in their agreement, advisable, put that thing in your agreement. The ADR clause or the dispute resolution clause, put it in your agreement, so that where there is a dispute, parties find it difficult to agree on how to resolve. So preventive purposes, they say prevention is better than cure. When you people are in peace, bring yourself together and say, this is business or this is agreement. We don't know how the thing is going to be like, but in case there is a dispute that is arising out of this, our arrangement, please, we are not going to court first. We are not going to court. We'll explore other means of resolving dispute. Agree first before you go into. So once you agree and you have that thing, so your arbitration clause or your arbitration agreement can be part of a separate document. It can be referred to by reference to a particular document. Maybe in your contract of employment, there is an arbitration clause. So when you are entering an agreement to do something, they make reference to that arbitration clause in your employment terms of contract or employment. Or it can be contained in the agreement itself, or you can now develop that agreement after the dispute has arisen, which we do not advise on many of the occasion. Please, if you are with me, can you give me a thumbs up? All right, thank you very much. So now, when you talk of arbitration, you have different types of arbitration. This arbitration, remember, arbitration has to do with commercial agreements. Arbitration has to do with commercial agreements. So when you want to arbitrate, you look at, is the dispute an international commercial arbitration? Is it an interstate arbitration? Is it an interstate commercial arbitration, or is it an arbitration that is within the confines? Is it a domestic commercial arbitration? So these are some of the things that you look out for. So once you establish and you have an arbitration clause, and then a dispute arose. Now remember, for you to claim that there is an arbitration agreement, that agreement has to be on writing. And that writing can be anyhow, whether it is piece of paper you wrote, whether it is by text message, whether it is by email. One of the innovation of this one is that they incorporate electronic means. So when you send a text message that make reference to arbitration to resolve your dispute, it suffices. If it is a WhatsApp message or a Telegram message, an email, in addition to written text, whether it is handwriting or it is the other way around, all of those things are veils. They are available and they serve the purpose. So arbitration has to be in writing. It must not be a formal writing like you have to type and sign, all of those things. Electronic means are also considered appropriate. Now, you should know that arbitration agreement is irrevocable. Irrevocable, except the parties themselves come and say, okay, we are no longer doing, we are no longer doing it. It's only the parties that can come and say, okay, let this thing be gone. And then because, it is party driven. But it will not be invalidated by reason of death. I've mentioned it before, or bankruptcy, or insolvency, or change in circumstances of any party. Arbitration agreement will not be affected in any of those circumstances. Now, the court has the power to stay proceedings and refer parties back once there is an arbitration agreement. So those of us who are litigious, you would rush to file in the court. The law says that if you check section 5 of AMA, tells you that, what you need to do is, where there is an agreement to resolve your dispute by arbitration and a party has gone to court, so what you're going to do is to file your notice of preliminary objection and do not submit to the jurisdiction of the court. You file notice of memorandum of conditional appearance, and then raise your notice of preliminary objection without filing your defense. And that is sufficient for the court to stay proceedings. Now, as to number of arbitrators, in the previous act, they say that you have 3, one by each of the party. Then they thought the chairman of the tribunal will be appointed by the 2 appointed arbitrators by each party. So, but the law as it stands now is that default state of arbitrator is 1 arbitrator, unless the parties agree. Otherwise, say, no, we have too much money to spend. We want 3 panel of arbitrators. That is their choice. But ordinarily, 1 arbitrator suffices. Now, parties are the one who choose and appoint the arbitrators. You need to take note of that. So now, once there is an arbitration agreement, for you to challenge it, the arbitrator has the power to rule. When you are challenging an arbitrator, where a person is appointed, or is approached for the purpose of appointment as an arbitrator, the person is supposed to disclose if there is any reason or any justifiable reasons that will make the other party to think that he's impartial or his independence in the matter will be brought to question. So that's one of the things that you need to consider, because those are the grounds that eventually will be challenged. If the other party is your former girlfriend or your former wife or your business partner or whatsoever relationship you have, disclose it and ask the parties whether you should proceed. If they say no, I'm not sure. Why is this so? Because you see, arbitration makes the arbitrator, it's like you are giving your life. You give the arbitrator a knife and say, please, I'm submitting my life to you. If you cut me, I remain cut. If you spare me, I remain spared. So it's like you trust the arbitrator so much. So because he's going to be taking a decision, it's not like mediation where parties will be guided to decide for themselves. In this case, the arbitrator will have to take a decision. So you are bound to disclose anything that can cause a problem, So that's the thing that you need to take note. Now, where you are challenging the jurisdiction of an arbitrator or a panel of arbitrators, they have the power to rule over their own. They have the power to rule over any challenge that you have, and their ruling stands. So we have to be very careful while appointing arbitrators, so that we don't go and do something that will end up regretting. So, and then as an arbitrator, don't be so quick to accept without being sure that you have what it takes to deliver. It's very, very important. Now, where an arbitrator is appointed, if you have been appointed as an arbitrator, and what will you do? What are you supposed to do? Where that you are appointed as an arbitrator, the first thing you need to do is you need to first, a letter will be written to you. You first accept the appointment and accompany it with a letter declaring that you do not have interest in the matter and you do not have any connection. You don't have any interest in the outcome of the matter. You don't have any connection with the parties, just as we stated. So you have accepted. Once you accept, what you need to do is to now, how do you do the appointment? Where you have an arbitration agreement and a dispute arose, and you have exhausted, if there are other means of resolving it and you have exhausted those processes, what you need to do is the party who is initiating or commencing the arbitration proceedings to issue notice of arbitration to the other party In your notice of arbitration, you state the agreement that you have, the nature of the dispute, and what actually brought about the dispute and the steps that you have taken thus far. Your proposed arbitrator is going to be written there. You say this is him, and then where you have attached his profile. Ask the other party to decide when. Let's say, please say something about the proposed appointed arbitrator within 1 week. After 1 week, it will be deemed. So once there is proper service of the notice of arbitration, your proposed arbitrator, and you cite the clause, the agreement that has the arbitration clause, and the breach, the nature of the breach, or that occurred, you cite all of those things and say, pursuant to so of paragraph so of our agreement, I'm not issuing a notice of arbitration. So the person will either accept or reject, and then he's supposed to respond, whether he has accepted or rejected the appointment of the arbitrator. But where he fails to so respond, and you say within a certain period, it will be assumed. So once that is done, after that period, the arbitrator writes to accept the appointment, and is going to invite the parties concerned to a meeting, the first preliminary meeting that they are going to be having. So having accepted, is going to send a notice of arbitration, a notice of arbitration to the parties, both sides, and ensure that there is acknowledgement of receipt. Invite them for the first preliminary meeting. What are they going to be discussing? You are going to be, the arbitrator is going to be laying his hand on the agreements of the parties, the contracts. He's going to look at it, and then you discuss important things like appointment of a secretary of the tribunal that we've mentioned, appointment of registrar slash secretary of the, most times the arbitrator has his own person that he wants to work with. You will bring the profile of the person and say, I'm proposing so person. So when you accept, and then you now say, okay, you discuss other things. What are the seats? If it is not expressly stated, what is the seat of the arbitration? What is the law that is governing the arbitration? You stated where is the venue that you're going to be using, where are you going to be sitting, is it something that you're going to be staying from day to day until you resolve the matter, or how many times are you going to be meeting in a week, in a month? How are you going to go about it? You're going to clearly discuss all these matters. How much is arbitrator's fee? How much is registrar's fee? What are the means of service? Is it service? Is it by courier? Is it by personal service? Is it by email? Is it by text message or by WhatsApp? Which one? You all agree on it during that preliminary meeting. And once you are able to agree on it, some of these important issues and matters, when are you going to start? Do you need an expert to testify? Is it document only? You want to do a kind of document only arbitration, or you want to call witnesses? Will you need the services of, will you need an expert to testify? You are going to agree on all of those things. And once you have agreed on those things, then the arbitrator, even having agreed on all of those things, okay, filing of processes, point of claim. Please confirm if you can hear me. I want to see your thumbs up if you are with me. I'm just
Yes, sir.
saying my story to myself alone.
No, we are with you, sir. We can hear you.
I want to hear from the mentees. I saw 2 people have left. Hello?
Yes, sir, I can hear you.
I can hear you, sir.
I can hear you, sir. I can actually hear you, sir.
Okay, so Dennis, you take note of all these people. I hope that they will be interested in enrolling for arbitration, for our certification. Settlement House has a certification in arbitration that will soon be coming up. So those who are interested, especially those who have taken part in this mentorship, we have a way of is it subsidizing, or there is a way we go about it. There are benefits for those who are interested. So please don't just stop here. So I'm telling you what happens in real life situation where these things come up. So once you finish, then when you finish the first preliminary meeting and parties are all present. Now, what happens when one party is not available? Normally, the arbitrator can continue once he has evidence that he has served. But for the interest of justice, you can adjourn the preliminary meeting to another date, give the other party, then serve the other party notice. Then, depending on your wish or your will, you can also adjourn again when they don't come to another date to do the preliminary meeting. But where after like 3 times, at the first time you can proceed to, but in the interest of justice, so that there will be fairness and that you are giving them opportunity, all these things will be recorded by your registrar, and everything, the record of the proceedings will all be available. So when at the 3rd time they come and they did not, you have agreed on the timing for filing of processes, point of claim, point of defense. Is there a counterclaim? What time do you need to file? I need 1 week, this other 1 week. If I have counterclaim 1 week, you calculate all of it. Then you adjourn the matter. You now say, okay, you agreed on the fee and the fee of the secretary. You said, okay, you issue your first order of direction. That will comprise the summary of the proceedings, the agreement that parties reach during the preliminary meeting, and the things that needs to be done. So in the preliminary order, in the order of a direction that you are going to be issuing, you are going to state parties have agreed to file their processes within 1 week, 1 week, reply or response within so period. Parties also have agreed to pay 70% of the fee for the arbitrators, on or before so to be paid into so account. Venue has to be taken care of. Administrative activities, the registrar and the tribunal secretary will take care of that. Payments for all those logistics are taken care of. You state it in your order of directions, and everything that parties have agreed. Then you may decide to call for another meeting. Instead of adjourning the matter straight, the proceedings straight for hearing, you can adjourn for another, maybe another preliminary meeting to finalize and check whether what the arbitrator has ordered to be done has been complied with. If you check and everything is done, you can now adjourn the matter for hearing. When you adjourn the matter for hearing, the hearing is also similar to what we have in the court system. You already have the processes, the witnesses, the documents that you want to tender. They are all before you. So if you want to tender it, if you finish, party, you take an oath. The procedure is the registrar is there to administer the proceedings. So the plaintiff is testifying for himself, or he has a witness. You come, you have submitted your point of defense, you have submitted your statement of your witness statement on oath, you have submitted all the exhibits you want to rely upon. You can say it is a document only arbitration. In that case, you don't need to come for oral evidence where party will be cross-examined. So okay, so during the hearing, The plaintiff testifies first. The registrar will administer the oath or affirmation to swear or to affirm. After doing that, you adopt your documents. The lawyer guides you, just like the way he announces appearance. He guides you, points to relevant paragraph that mention the documents you want to tender. There is no objection, my arbitrator. Before that one, there is nothing like that. The rules of evidence does not really apply to arbitration proceedings. So it has a form. It's like litigation without wig and gown. All the strict procedures and all those technicalities are not there. That's why you see even non-lawyers are arbitrators. You see engineers, you see people from different fields also, they are also arbitrators. To encourage you that once you are interested in, you can become a mediator, you can become an arbitrator. At Settlement House, we train and certify mediators. We train and certify arbitrators. So in case you are interested and you want to take part, please don't hesitate. Reach out to Dennis or reach out to me. We will sort it out. If our training is coming up, we'll know how to go about it. So, but then the procedure is the same, it's similar to that of court. So your lawyer announce appearance, tell the arbitrator, those who are around and those who are representing the witness that is available. He comes to the witness box, he deposes, he swears, and then he adopts his processes, tender the documents, draw the court's attention. And after doing that, the lawyer on the other side has the right to cross-examine him. So also that happens to also an expert which is appointed by the parties. If it is an expert that is called, the arbitrator must have made arrangement for an expert who is going to come and testify for both. Both parties may have the right to cross-examine that expert. And after that, you will be discharged. So when you are done with your, the party has been cross-examined after testifying, you will now take a seat. Then the defendant the respondent comes in. The 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 respondent comes to the witness box. He's guided, he affirms or swears, he adopts his process. Documents who are there are referred to, and tendered, and then after that he's cross-examined. Once he is cross-examined and the matter is closed, then you agree. In your preliminary meeting, you must have agreed whether parties, the lawyers are going to have time to address the court finally. So if they've agreed whether that address is going to be 5 minutes or 10 minutes, whether it is going to be oral or is going to be written, those things are the things that has to be agreed by parties. Based on your agreement during the preliminary meeting, after the close of evidence, parties may take 1 week, or they will address the arbitrator immediately, considering their time. And then after the address, one person address, the other person address. You can cite law and evidence that supports your matter and your case. That will guide the arbitrator in case if he's not also a lawyer, that will give him a proper guide or give her a proper guide, as to what the law says and what case laws are saying on similar issues, especially if they are arbitration issues. So once that is done, the matter is now adjourned for the award to be published. Before the award is published, a registrar is going to confirm that everything has been done. Payment of outstandings, everything that needs to be done is done by each party. And once that confirmation is made, the arbitrator can go ahead and publish the award after the time agreed. If it is 1 month or 2 weeks after conclusion of evidence, award will be delivered. And so if that happens, that brings the arbitration to an end. Now, briefly on the registrar. Registrar has a lot of duties and responsibilities. Now, immediately after the proceedings of the day, The registrar's responsibility is to transcribe everything that is written, both recorded version and the script, transfer it into a script. He's going to write it out word by word and ensure that it complies with everything that has been said and discussed, and then the evidence will be made available to both parties you serve. Communication ceases once the arbitrator is appointed. After the preliminary meeting, you go into, you have anything, you file it with the registrar, and then the registrar will communicate with the arbitrator. You don't just call the arbitrator directly, you deal with the registrar or the secretariat for the purpose of administration of this. So you have different career opportunities. You can specialize in commercial arbitration. You have all this interstate arbitration. You have um, investment arbitration. You have commercial arbitration, domestic arbitration, international commercial arbitration, domestic arbitration. You have different types. You can be a tribunal registrar. You can specialize even in the arbitration field into different forms of arbitration. You can go into mediation, medical arbitration. You can go into labor disputes. You can go into a lot of areas and fields, in that field. Mostly we advise people, if you are a specialist in commercial law, dive into that area. If you're a professional in medical law, if you're a contract, if you're an estate person, estate surveyor, estate whatsoever, dive into that field. You have it. If you are, let's say, an engineer, dive into your field. You can be a good arbitrator that has to do with construction industry arbitration. Specialize in this area. You have construction dispute arbitration. You have employment dispute arbitration. You have several arbitration, medical dispute arbitration, and all of those things. Some of those things have constitutional provisions that say, before you can take a matter to court, you must set a tribunal who is going to arbitrate. You set up arbitrator, you have to arbitrate before all those things are done. So you see, these are all the things that you need to know and that we just touch here and there. And that's why we said that it's better when you ask questions, at least we have a direction. So with this, I can say thank you very much for listening to me. I'll hand over to Dennis for him to continue from there.
All right, thank you so much, sir, for a very, very insightful discourse from you. You're able to, in very quick terms, highlight several things as pertaining to arbitration, including the introduction that was done from Ms. Omotayo and then the feedback and contribution from Ms. Mispa. I can say we've touched on almost everything that pertains to arbitration, but like Mr. Nacham rightly pointed out, if you want to become a certified ADR practitioner, right? You want to become certified within this field, you can do that with Settlement House ADR Institutes. They'll be having their training coming up soon. You can reach out to us. There will be a discount for those who are going to be joining that training through the JIIPCC Mentorship and Internship program. So you can kindly reach out to me or Mr. Nyacham. He's on the group, to send your name and to indicate your interest in becoming a certified practitioner within the ADR space, right? One of the core purpose of JIIPCC is for also further internship or placements, right? Just to help you build in terms of your career aspirations. So this is an opportunity that is brought to you in collaboration with Settlement House ADR Institutes, ADR Institute. So please, let's not sleep on this opportunity, right? Let's take full advantage of it. Just before we call it a night, right? Please, for those who have lighting in their background, please, can you kindly turn on your videos? Let's take a quick screenshot. I think we will be doing this much earlier so that, we don't have those issues with, having lighting. Thank you so much, Mr. Nyacham. Thank you, HP. Sorry, please, maybe in our next class, you can just kindly rename yourself so that we know you. Thank you, Ifunaya. Sorry, did I say Ifunaya? Thank you, Perpetual. Sorry, 1 minute. All right. Okay, we're done. We're done with that. Thank you so much, everyone, for joining in into today's class. It has been a wonderful and interesting session. Thank you so much, Pina, for indicating your presence. I wish everyone a wonderful night's rest. Please do enjoy the rest of your evening. In our next session, rather than taking presentations, what we'll be having is simulation, mediation simulation. So the task for the week will be a simulation, right? And it's expected that the two groups will participate in this simulation. Please and please, we want to have collaborations, and we want to have the members of this group participate fully. We will not be having a presentation, we'll be having simulations. So you'll be asked to perform in a particular kind of way, a certain role aside to, discussing about mediation, right? So please look out for the tasks of the week on your group, right? And prepare in accordance so that on Wednesday, that is next week in our next class, we're able to do that without any issues, right? So please do not forget to post what you've learned in today's class. Share on your different social media platforms, tag JIIPCC, tag Shakti, that Settlement House Area Training Institute. And, I'm sure, we will have more people joining on board and get to see what is happening within JIIPCC. You don't really get this opportunity in other places, right? So thank you once again, and please do all enjoy the rest of your evening.